Good afternoon. We will be starting in this, 1 minute. Good afternoon, dear guests, dear speakers, dear participants. It is my great pleasure to welcome you to the conference Space Law at the Crossroads, Sustainability, Commercialization and the Future of Space Governance, organized along the Manfred Lachs Space Law Court Competition European Rounds 2026 here at Faculty of Law and Administration of Anna Mickiewicz University in Poznań. At this outset, I would like to sincerely thank you all for joining us today. It is a great honor for us to host this event and to welcome such a distinguished group of guests and speakers to our faculty. I would like to express my special gratitude to the Dean of the Faculty of Law and Administration, Professor Tomasz Nieborak, and the head of the Department of International Law and International Organization, Professor Boubacar Sidi Diallo, for their support, trust and kindness, without which this conference would not be possible. We are particularly pleased in the first conference of this kind devoted to space law and governance hosted on our faculty, and a special privilege for us to welcome such an outstanding panelists to the discussion some of the most important legal and policy challenges currently facing the space activities and space governance. Today's conference is structured around two thematic panels. First, we'll focus more broadly on long-term sustainability and the future of space governance, while the second will address the growing tension between sustainability, commercialization, and the role of new actors in the space sector. It is my great pleasure to open the first panel towards sustainability in space governance. This panel is devoted to the broader and more structural dimension of sustainability in outer space. It invites us to reflect on the diplomatic and legal efforts surrounding the long-term sustainability, the role of multilateral process and soft law instruments, and the future of shape of international space governance in increasing complex and crowded space environment. It is my pleasure to introduce you our distinguished panelist, Professor Katarzyna Malinowska, Associate Professor at Kosmiński University in Warsaw, Professor Malena Hoffman, a Senior Professor of Space and Telecommunication Law at the University of Luxembourg, Mr. Niklas Hedman, a former Advisory Director of UNOSA, a long-serving Secretary of Corpus, Dr. Merva Burger, an independent space law and policy consultant based in Switzerland, and Dr. Rosa Banzo, a representative affiliated with the Faculty of Law in Bergen. Thank you once again to all panelists for being with us today, and I would like to for a small applause for our panelists. And thank you once again for being with us today on this conference. Without further delay, let us bring our discussion. But before turning to the specific issue, I think it's useful to bring with the broader picture. Sustainability in outer space is in longer term. It's not only a technical concern. It's become a central governance issue, questioning in the space governance and the whole space diplomacy environment. My first question for the panelists, therefore, is this: how you see the current place of the long-term sustainability within international space government? Is it primarily a diplomatic and soft law project, or is it gradually becoming a more concerted operational and legal standard? would you like to start with on this question?
Thank you. I think I could start then. So if you look at long-term sustainability of outer space activities it has been handled by the global governance level, namely the Intergovernmental Committee on the Peaceful Uses of Outer Space, COPUS. It has quite a long history now, nearly 15 years. It took 10 years to negotiate and arrive at a consensus on the long-term sustainability guidelines, a soft law instrument, and we know the difference between hard law and soft law, obviously. Now it is a little bit of a fatigue on that process, but COPUS last year actually, instituted an expert group on space situational awareness. And what I'm addressing here is just some initial thoughts that when you, in your question, distinguish between diplomatic consensus and practical governance, and that is quite important, you know, what are we talking about here? Obviously, at the intergovernmental level, it's diplomatic consensus which is driving, you know, the whole work on the global level, so to say. Practical governance is the next step, but we are not really there yet. Member states, the 110 states members of COPUS, including all the major spacefaring nations, are now embarking on the embryo, I would say, towards more practical coordination, not only cooperation, but coordination, particularly on SSA. And we will see what emerges in the next step. This is still more of a diplomatic governance framework, but we try actually to get the major spacefaring nations to embark on coordination efforts when it comes to SSA. We are not really there yet. And the biggest issue, I would say, and maybe this is where we will have a discussion, is whether private sector, industry, and commercial and private entities should also take part in the global governance of outer space activities.
So if I may, I absolutely agree with that what Niklas said. I would like to enlarge it a bit. Of course, there is, on the one hand, there are intergovernmental relations connected with diplomacy and then also with adoption of public law instruments. But on the other hand, we can see also that there are needs of the operators, and the sustainability is nothing which came from the sky. It's something which is needed by the operators. We can see it more and more on the low Earth orbit with all the crowded orbits and the places which have to be coordinated. And I see in parallel what Niklas said, also a development in other areas like standards. I will have an opportunity to speak about it perhaps in a minute later, but there are many standards like on the geostationary orbit or on debris mitigation or even on the quality of rocket propeller, which are less detrimental to the space environment. So we can see that in parallel we have a development where the operators themselves and the company themselves are interested in having some operational rules which would avoid that their own activities are hampered.
Yeah, I could not disagree. So I would like to develop the plot of the technical standards, because in fact what we are missing now is a diplomatic consensus, like Nicholas stressed, that it took almost over 10 years to agree on soft law, not even discussing the hard law, so the consensus like treaty-like. So maybe we should give up the hopes for the moment, given the geopolitical situation, to try to negotiate a treaty humanity or something which is more hard than soft. But then, as Professor Hoffman pointed out, that we should implement or try to implement the coordination rules between the governmental stakeholders and operators, and then when we focus on the bottom-up approach and work from the technical point of view, not from the ideas point of view, where we disagree recently so strongly, then maybe it would be more practical. As we are discussing the standards, there are standards everywhere we can, they are politics free or ideas free. They are just practical, and what we really need to not focus on any political side, but what's practically needed, and that's operators are really ready to provide, because that's in their own interest, and what's in their interest that finally will be, from the sustainability point of view, in the interest of the countries and humanity. Of course, maybe the commercialization point can be a bit disputable, but let's discuss on that, how operators' interests are or not contrary to the interests of the governments. Yeah, I would go to the technical path, more than diplomatic path at the moment.
Yeah, thanks for this opportunity today to address this topic. That I really love the concept of sustainability. I love this concept that it was formulated by the UN in 1987. So this concept came 39 years ago. And you know, we are still, after 40 years-ish, still discussing whether natural resources and spare resources, because we are shared resources like common resources, should be governed by the principle of sustainable development. And then I think it's it gives you a sense of how innovative this principle has been, and how much has been, in a way, states that have been not very, let's say, states as subject of international law and also international politics, have been very reluctant to accept the legal bindingness of this principle. So 40 years, right, is a long period of time. So I think, as has been said, we are in a really crucial geopolitical time, and we see a kind of regression, can we say? So we have been witnessed the recognition by states of the concept of sustainable development, especially around the 2015. So when we have the Paris Agreement was recognized, so we were all on this, like, yes, let's do better, make the planet, also the outer space, a place for everybody, for the future generation and for the benefits of humankind. And then, like, suddenly something has changed. But I think, like, despite of the legal or the international geopolitical context, the lawyers, we have tools. And I always think that says the governance that you were referring to is our field when we can operate, even if the political will is not there, right? So space law is a part of international law. I don't believe in the idea of fragmentation, right? So there is also part of international law, like supporting this idea. But I'm more with the idea of a comprehensive international law. So even though there is reluctance by states, we can still look at international law as a big regime, all connected together. So I make this sustainability principle more and more alive. So then I think it's true that we are, of course, assisting to a very difficult period, but the skills that we have, they will really make a difference. So I'm not optimistic, but I'm more ambitious, right? So I think that is something that you have to keep in mind. All your skills for today, they will make a better future, even if other forces or other powers, they will be against it.
I'm not pessimistic about the future, because as we see within the corpus, there is a second working group on long-term sustainability discussing. Of course, it will take a while to reach the consensus on the adoption of new principles to cover, to be covered by LTS guidelines, for instance, maybe circular space economy in orbit services. So it will take time, but we might reach to consensus on the new guidelines. And meanwhile, we see, as already stated, technical development of technical standards, but not just technical standard, as well as the best practices, guidelines, or principles adopted by the industry associations. So even though there is no international governance framework on certain activities, industry takes further step to provide guidelines for their members, and then these guidelines became in a way not binding but implemented within national space laws because they refer to these guidelines. For instance, in orbit servicing is an emerging activity, and we don't see a general adopted guidelines on it. And there is this association called CONFERS, established in the US, and they adopted their best practices. And in New Zealand, for instance, policy on in-orbit servicing activities, they refer to CONFERS guidelines on in-orbit authorization on in-orbit servicing. So industry and national states are taking over to fill out this gap. So I'm not, again, pessimistic about the governance of sustainability.
I would like to add something because we are quite excited about the developments of the Polish space law recently. It was adopted by the Parliament on 13th of February and just now signed by our President, so it will come into force very soon. And in fact, that's something I can refer to because Polish space law refers to international standards that concern sustainability, and these standards, to make the life of operators easier, will be announced by the Polish Space Agency after the law comes into force. So that's the also kind of bottom-up approach, because even if we lack the diplomatic consensus, we can interact between the agencies, between the operators who influence the national laws to make the standards compatible with each other. And that's why we achieve something we cannot achieve on the high level.
If I may just, the standards are usually considered to be recommendatory. But we can also make them binding. So we can make them binding by a reference in a contract, for instance. Or we can make them binding in a reference in a national law. I would have an example of a Luxembourg law which refers to standards dealing with some fuel composition and so. But it is possible to make standards also binding.
Yes, absolutely. What we are addressing here is very important, that it all boils down to how states domestically implement their rights and obligations under international law. And here I also include soft law. For instance, when it comes to the long-term sustainability guidelines that we had talked about earlier here, there was really a lot of confusion and divergent views among member states on whether those really addressed sustainable development on planet Earth, or whether it was something else, the sustainability of activities, and whether the space environment was limited to Earth orbits, or whether also celestial bodies, the moon and other celestial bodies, would be included in that concept. And there are still different views on that. But what we see are more and more states that are in there, when they are establishing their space legislation, national space legislation, or they are changing their already existing acts. And I'm now referring to my own country, Sweden, which is now in the process of amending its Space Act, which was originally from the mid-1980s. And in that process, the Swedish government is actually looking into the long-term sustainability guidelines as a soft law instrument, and also applying those guidelines into the legal framework, which I see more and more states doing. And we also see states actually taking a stand on including celestial bodies in the concept of the space environment, which is interesting because this is a constant dilemma at the global governance level, whether the space environment is only encompassing orbits around planet Earth, or whether also celestial bodies are included. But we see in practice that more and more states are actually taking a more bold approach.
Thank you very much for your insights, but I would like to direct our discussion more into the implementation. And I would like to ask you, because we have, of course, the instruments of soft law, we have national law that refer to the standards, to soft law, but we have no international binding treaties that create the comprehensive system of how we should look for the sustainability. In your opinion, is there any chance that in the future, in the current geopolitical situation and in the current state of Corpus working and the UN, to get new space treaty on sustainability, that would be the most important treaty to continue the work of the treaties from the 60s and 70s? So,
unfortunately, I'm very skeptical that at the present situation it would be possible, but I see a lot of movement on the regional basis. And it's not necessary to go far. Everyone knows that the European Union has submitted this proposal on the European Space Act, which speaks a lot about sustainability. I am sure that the colleagues will speak also about it. So I see developments or some potential on the regional basis. But Niklas, perhaps you have a different opinion.
No, but no, I don't have a different opinion. But I would not say that. So this actually goes back to the whole discussion whether the outer space treaties are outdated, whether we need to amendment, whether we need new treaties, etc. And if we look at space activities with the technological advancement, you know, everything that is having the proliferation of the entire space sector, it's remarkable that we have the founding treaties from way back 1967, the first treaty, Outer Space Treaty, and then during the 70s, that they are still applicable and that they are actually really, I would say, relevant for today's activities.
I might add something. When I was an academic in public international law, I was very support of binding treaties and or also the binding nature of international law. But we see that even though prohibition of use of force could be breached very easily, therefore I'm not sure if adopting a binding treaty would be enough to really make space activities sustainable, because at the international level we have the problem of consent of the state to be part of the treaty, and also enforcement. If it doesn't implement, there is no really strong enforcement mechanism to make states to implement it. So it's again coming up to the regional solutions, like supranational organization adopting regulations or national space laws. So we are really at the discretion of states to adopt sustainability principles within their national laws. And again, for international law part, Again, I'm not sure if we need to update for the sustainability of space activities in terms of especially environmental protection of space, because there are already customary international law principles in environmental law which are applicable for other space activities. And like when we look at the recent ICJ advisory opinion, precautionary principle or impact assessment for activities, for instance, could be applicable for other space activities. So if we want to look at, we can find already existing sources.
If I don't have a clear opinion about that, because I think you can have a practical approach to it. So, and there is a general idea that it's so difficult to get all on board and to also agree about a legal text, because there are many, many interests from different states, and the negotiation they used to be very, very long and very, very expensive. So it's also in terms of costs, right? So sometimes it's, I think if you take this approach, there you will see that it's very, very hard to come with a new agreement. Then on the other hand, you can think about, why not? We have a new generations coming up, so there will be maybe different ways to deal, and especially after what we have seen, geopolitically speaking, maybe there will be, a stronger intention from a new generation to make binding agreements, because we have seen how there have been disregards and how the system has been disregarded so far. So maybe there can be a change because we want to reform the UN system. So we are, you can argue from both sides, and it's not crystal clear, I think, what will happen in the next decades. But one point is, and I agree with all of the speakers, international law then is still alive in a way or another. So we have soft law skills and soft law documents that can be used, and that can be, in a way put the seeds for more and more development. So also this is the way that international law has been built along the history. So before we have been, started with soft law decisions, and then we're slightly moving to something that is more and more legally binding. So as I said, I don't have a clear opinion about that. So because the situation, they are really evolving very rapidly. So I think it's in both ways. Something will happen anyway, and maybe we will see a big change. I don't know. I mean, I can't predict what will happen, to be honest.
A few words to add from my side. Indeed, thank you for that about the value of the international law. Personally, I would not also make the international space law a holy grail, the treaty law, I mean. Because first, we have other branches of international law that can be applicable, as you said, environmental law. Then the international law, what we can say, we can observe sometimes it's a kind of erosion of international law by some harsh words of some politicians. So then we are not certain how to interpret it, etc. And I would rather, and I'm saying it as a European, that's obviously, I would rather go for strong and ambitious European space law than fighting for some compromises on international law level. And I'm very proud. I don't say about the content because it's too detailed. There are many detailed documents. But as an idea of enacting regional European law, as an ambitious text. That would serve the sustainability inter alia. Yes, there are many aspects of that. We can probably discuss it further, and make it really bold and make it ambitious and count that the rest of Europe, rest of the world will follow. So we can be ambitious enough to create a kind of golden standard, and we can see also on other levels that the rest of the world is following, like GDPR. That was a golden standard, and we see that the US start to adjust the other jurisdictions. So, and even when you read some statements or opinions analysis from US that they are a bit afraid of European space law, good that they are afraid, because that's something that that is a hope that we somehow communicate on the level of regional law, and we can easier reach consensus, obviously, on the European level than on international level. So yeah, that's it.
One question that I have, and I have been asking myself for some time, is whether space activities would have, I would say, the same evolution as other traffic domains and regimes, like maritime traffic, aviation. And we see in the areas of aviation and in the area of maritime traffic, we see quite robust intergovernmental mechanisms with the full-fledged with treaties, with the regulations, with the enforcement mechanisms. And I'm asking myself whether space would come to a stage where it would be mature enough to be seen as a traffic regime and develop into the same that we see with maritime and aviation. It's a question I'm always asking myself, whether we would come to that time, you really, to see that mature.
I'm afraid to come to that era because I cannot imagine the environmental impact of that traffic. Therefore, but at the same time, I don't want to say that I don't want, because we want innovation and development. So I am in conflict.
If I should respond to your question, I think it depends on the intensity of the activity. We saw it, for instance, in the case of suborbital flights. Everyone knows that they are the flights which might reach the orbit, but they do not complete a full orbit. So also there was a lot of discussion whether or not they should be regulated, also on the level of the International Telecommunication Union, whether they should be special frequencies allocated to this service or not. And then even the ITU, which is very pragmatic, says they are not, that's not their daily practice where we would need binding rules, specific frequencies. Let's take it when it's in air, let's take it as an airplane. When it is in reaching outer space, let's consider it to be a space object, so with a space, using space frequencies, but let's don't create a special regulation because it does not take place every day. So I think that it could be also a rule in the case of space activities. They do not take place every day, but at the time that they will be so intense that a regulation will be needed, so the day will come.
Thank you for your insights. But when we are speaking about sustainability, we cannot disconnect the safety and technological coordination and the care of environment that is always included in sustainability. But we need to also look on the fairness and participation and access in the less developed countries. So my question is, can the future governance remain sustainable and also equitable and fair for not only the countries that are leaders of the space exploration, but also for smaller and less resource or less technologically advanced countries that are joining to space activities, to space sector, and they are facing the hard situation when they need to adapt to the really high standard of soft law mechanism, or for example like European Union Space Law Act that we will have in a couple of months, I think. They try to impose the really high standard for not only the European countries, but also for the countries that we will cooperate with. So my question is this situation can stop or be a problem for the smaller countries that we want to join us with the space exploration, space activities?
I can start. That's for sure. I think that's also one of the issue with European Space Act. We already know 14 member states of the EU has already, and by this signature 15, congratulations. So it reveals some form of preparation in a way, but the rest still doesn't have any law and policy, even developing space industry. That will be definitely difficult for them to adopt and implement those high sustainability standards. Then it comes to the question of capacity building. I think, adoption of ambitious regulations is a good start to also drive the world onto space sustainability, but you also have to support industry and also small countries, and it's up to, again, EU politics.
Yeah, I totally agree. And actually, if we look at, your question is, to what extent do we also include emerging space powers and emerging space nations, I would say. And in that sense, it is crucial that we uphold a global system so that we have an intergovernmental meeting place where all countries, as far as possible, can attend. So that if for inclusiveness we also include emerging space nations, developing countries, that is fundamental. But at the same time, I think that also the major spacefaring nations and their respective space sectors, they need for us that are designed for their demands. So there are different levels on how we see governance. I think that is probably what would be also the easiest way forward to allow also the major spacefaring nations to coordinate among themselves, and we need them to coordinate among themselves. So we talked about Europe here. Yes, it's fine, Europe at the regional level, but we also need the global level. We need the powers from different geographical regions to coordinate better. And we see that also already since many decades, particularly in Kupus, where we had a very active working group on the use of nuclear power sources in outer space, which only a few countries really have capacity to use nuclear power sources. And actually, those countries came together and they had a little bit of a closed environment where they outlined, the MPS principles, the safety framework on the use of nuclear power sources. And that was kind of important, that they could do that without interference of, the issues surrounding industrialized nations versus developing countries. So I think it's different levels of governance that is needed.
Oh, yes. I will be the nerd student that give you some more legal content. So the procedural justice that we are talking about in scholarship speaking is a core principle of international law. So it's not we are posing something that is, no one knows. It's something that has to inform any process of international law and international negotiations. So it's a problem that we are facing, so not to in a way, satisfy the procedural justice requirement in any field of international law, also because we have been seeing opening up the international law to subjects that are not just barely states. So we want to give voice also to stakeholders, so the private actors like in this case, but also to other, especially that is the sustainability principle that it really brings up to open up the idea who are the other stakeholders. So also to future generations, also to indigenous people, because they are all part in a way of the process to making a new law, or also to discuss what is the relevant interest and stakes and what we should consider as like interesting problems to take into account when we implement, when we comply with the law. So that is a very like core issue in international law, and even more now is coming up when international law, international space law is opening up to private actors. So we will really see. So this is the procedural justice. You can see this principle on two sides. So one side is to make the negotiation very transparent and open to all this, and call all these guys to come and join. So that is the like formality. But then is also a substantive part of procedural justice. So make the voice really heard. So that's something, for instance, that's been very like the biggest challenge in international law, and maybe can be also regarded as like the why has been a failure of international law. Because when you talk with developing countries, that they are like they are seated around all of us around the table of the negotiations, but they struggle to be heard. And there could be also like very practical like issue, like the language issue. Like sometimes, I mean, it's understandable. People that don't speak English, they felt out of the negotiation because they don't have the same ability to interact with the other states and the other actors. So these are problems that we are facing during the negotiations, and then they should be taken into account. So that is, I think, the role also that we have as lawyers. So when we speak about, okay, there is a procedural justice principle, it has to be informed international law, but how to make this principle implemented in the real world. So that is always something. So there is something that you have to take into account when you look at principles, is to see, okay, how many faces has this principle? And in reality, how it's working. So in international and space law, we have this problem. Like especially I have been, from a public international law side, I have been very digging into the problem of indigenous people perspective in international space law. And there was no sign of indigenous rights in the management of international space resources. And I checked all the UN documents. So the first sign came in 2023, right? So it's very late. And we know, most of the space launching facilities are really placed in very special places in our own countries, like in the north of Norway when I work, so when we have the summit, for instance, and in other very special areas. But no one really thought about, let's ask these people what they think about, So that's our also issues. They are there are common failures in international law, but maybe they are more evident now because we are aware, right, of what is the principle of fairness, procedural and fair means. So that's my point.
So I'm for pragmatic solutions, and because of that, I would like to draw your attention on the management of the geostationary orbit. And you know that each and every country of the world has an accorded position on the geostationary orbit. What the country does with its position is its own full discretion. You can say, but who is today using geostationary orbit? The problem is the LEO, the lower orbit or the medium orbit. So perhaps we can think how to transfer this allocation of spots on the geostationary orbit also to the other orbits. Second remark, for instance, Rwanda has filed for 40,000 satellites on the LEO. So I think when we are speaking about how to cooperate with the colleagues from the developing countries, we should also take them on the board when discussing the sustainability of the activities. So we should discuss also with them how to protect together the environment.
In that sense, not from a legal perspective, but more from a policy perspective, as we know, outer space, or I would say the space environment, has never really been part of the global agendas for sustainable development until 2024, the Summit of the Future, which resulted in the Pact for the Future. And we can, of course, debate, the relevance of that instrument, but still, it is a fact that outer space got a paragraph, a paragraph into the Pact for the Future, which is promising because I see that as possibly a bridge towards what will come post-2030. When the 2030 Agenda for Sustainable Development is concluded, there will probably be a new agenda, a global agenda, and in that global agenda, outer space must be part of the global agenda of sustainable development. We cannot only continue having only planet Earth being isolated from, I would say, the solar system. So I see that as a promising trend. Hopefully, now when we have probably in the future, we will come over some of the current geopolitical issues, and probably the world community might be able to look beyond and see that outer space need to be part also of sustainable development efforts.
Well, there are campaigns to add outer space as one of the SDG 18 principles, but considering the implementation of SDG principles already in place, I don't know how it would help to again for the governance of sustainability or protection of outer space. So it's also questionable.
Thank you very much, and perhaps maybe for a final reflection and final question about sustainability. As many participants here already know, space activities are ultra hazardous activities, of course. Should we see the sustainability as a really broad concept, including not only traditional meaning, but to the system to develop and include more elements for the future and better sustainable space governance, or in the current situation when the multilateral diplomacy are in a little bit crisis, we should more focus into the most important part of sustainability and space law, and to securing the long-term protection of the orbit and environment in the crucial way that we need for us now and for future, to maybe not scare other countries that are not so developed, and they will see our over-regulated soft law mechanism and soft law instruments that are already problematic in UN Corpus, when the countries cannot agree on the really the best solutions that are, for example, not achievable for the less developed countries, or we should go with this sustainability as a motor of space law governance.
Yeah, maybe to start, what's the meaning of sustainability as the in the light of the governance? Whether when when I'm talking to, for example, to the Polish stakeholders, they see like sustainability. I don't say that it's non-existing, but it's in the shadow of safety. Absolutely. And if you ask anyone what are the efforts and where are the efforts going, where are the financing is going, is the safety, not sustainability. And so maybe would be better to make the sustainability give the room of the concepts which are en vogue now or important now, give them space in sustainability and not separate those concepts. Because we cannot live with sustainability, but first of all we have to feel safe, and the space is critical for that. Yes.
So maybe I will a little bit evolve this question into how sustainability can reinforce other space law key principle. For example, do you regard safety or even peaceful use of outer space? How we can use sustainability to make the standards even higher, better, and more safe for us and for the space activities? How we can connect these concepts?
Like for doctoral dissertation. Yeah.
Well, and just to add to what you say, what makes it even more difficult or problematic is that we have safety, sustainability, but also security. And in that sense, there is obviously a trend for security dominance. And I don't have an answer to that that complexity.
Of course, I have an answer in this case. No, because I've been working on sustainability for a long time. So, I mean, not as much as you have been working. So, of course, it's relatively long in sense of like how specific I've been looking at this concept. So if I'm not wrong, sustainable development also is a principle that's been mentioned in Artemis Accord. It surprised me because they mentioned this principle, and I was like, okay, so that is a good sign. I think it's in the. I remember that I read it, but I can be wrong. But the problem is, go back to the principle of sustainable or sustainability. I know that the industries and the guys that work in private sectors, they don't have idea what sustainability means. And sometimes when I teach, students are really skeptical. They are like, oh, but it doesn't really have a meaning, right? But it has a meaning. I mean, as a lawyer, we made this principle, right? So it was not something that came from the sky. It was really thought to be like sustainable development as something that came from in 1987, so you can find the Brundtland report about it when you find the definition, and then it was also in the Rio Declaration from 1992. And it's true, it was originally connected to the environmental law and natural resources, but in general we can see, or we can argue as lawyers, that global commons, as the outer space has to follow the principle of sustainable development. So that's just one argument that we can make. And in this sustainable development, you have the idea of don't use the resources the way they compromise future generations. So it gives you the idea of okay, let's use these resources, but in a way that we can share it between us. We are all bounded to protect those resources together, but also the future generation, they have the same obligation, and they should have the same opportunity and benefits from using these specific common resources. So then it's something that we already see in the outer space treaty, where there is the idea of not appropriation by states and the benefits for all humankind. I mean, it's not sustainable development in the written terms, but you see there are seeds. I mean, not appropriation in really remind the idea of a global commons and all the benefits for all humankind. I mean, it's not just the present generation, but also the future generation. And security, I mean, security, safety,
we can read, I think, as lawyers, those two terms under sustainable development. I mean, can be hard to argue maybe because safety has a very preventive nature, but this prevention, principle of prevention, is a part of sustainable development. I mean, what sustainable development means is like make use of the natural resources that you have in a way that you don't hamper as well future generations. It's something that is a preventive principle in itself, so we can argue in this way. So I don't think we are, I mean, there are ways, I think, and like legal grips in the actual regime that they will allow to argue for sustainable governance more than what has been in a way argued by some of the scholarship. So yeah, that is my point.
Thank you for your question. I don't think that we have to advertise for space sustainability. The operators know this, that it's extremely important to them to keep some rules to survive in this environment. And just to mention collision avoidance, ISO 23705, or space debris mitigation requirements, ISO 24113, used by the ESA, and we have the rocket propellants, ISO 1411001. So for the operators, it's clear that some rules are necessary. Otherwise, their activities would be really hampered. They would not be able to proceed as they wish to develop their concepts or business models. So I think it's not necessary to make an advertisement for that.
Thank you very much to all our wonderful panelists for this truly insightful discussion. Unfortunately, the time for our first panel is already over, but I believe this panel has shown that very clearly that sustainability in outer space is not only a technical issue, but it's also a legal, diplomatic, and institutional one that we can discuss here for a couple of hours or even write a couple of PhD theses and books. And we will still have many topics to discuss. And now we'll have a short break. For 15 minutes, and we'll be back here for also really important question with sustainability connected to commercialization and the role of new space actor that we already touched a little bit on this panel, but on the second panel we'll fully focus on these issues. And once again, thank you very much.
Good afternoon, everyone. Welcome to our second panel on sustainability versus commercialization, the role of new actors. We are witnessing a profound transformation of space activity. What was once a domain dominated by states has evolved into a dynamic ecosystem increasingly shaped by private actors. The shift raises a fundamental question. Are we still operating in the state-centric legal framework, or are we already moving towards a system where private actors shape governance in practice? At the same time, the rapid expansion of space activities, especially mega-constellations and lunar ambitions, forces us to confront another tension. Can commercialization scale without undermining the long-term sustainability of outer space? Now, let's briefly introduce our distinguished panelists, which they will do themselves.
Good afternoon. My name is Cécile Gobert. I am the General Counsel of ExoTrail, and I thank the organizer to give the voice to the operators within the space sector activities. I've not always been General Counsel. Before joining ExoTrail, I was an attorney at law, and I was running my law firm dedicated to space law activities.
Good afternoon, everyone. My name is Kaja Hoppe, and I'm working mainly within the Polish space sector. I work as a lawyer in the Polish Academy of Sciences, in the Space Research Center, as well in the Association of Space Entrepreneurs. So I'm connected with the public and private sector. And yeah, thank you for giving me the voice to tell a little bit about it today.
Good afternoon, everyone. My name is Héloïse Vertadier. I'm the legal counsel of iSpace Europe. iSpace Europe works with space resources primarily. We launched a rover last year and a couple of missions, the year before. So really about the operator and the practical aspects of, space law. That's what I will be focusing on. And thank you again for the organizers to give the voice to the industry.
I try this. Thank you. Yes, good afternoon. My name is Martin Reinders. I'm working with the German Space Agency at DLR in the Department for UN Affairs. And for this panel, I'd like to share some views on the more governmental side and what states can do to ensure that there's not just some minor self-regulation by commercial actors, but that the rule of law also is upheld in outer space. Thank you.
Good afternoon. My name is Jean-Marc Desved. I'm a research associate of the Planet Stewards project hosted in the University of Utrecht, and I coordinate the Space Law Research Center in Lisbon, where, amongst other things, we also provide support to the Portuguese space ecosystem, and especially public regulation and through the Portuguese Air Force.
Let's get to the topic then. Thank you for joining us. We often say that states remain the central actors in space law, particularly under Article 6 of Outer Space Treaty, which assigns responsibility for national activities in space. But in practice, we see private actors operating on unprecedented scale. To what extent are new space actors now shaping space governance in practice beyond formal regulatory frameworks?
Do you want, Martin?
Please start.
Okay. Okay. First of all, I want to thank Professor Hoffman for what you said earlier about the industry and the operators, and the fact that today the utmost interest of the operators within the outer space is to have a sustainable space to be able to perform our activities in a right way. This is very important for us to be able to do that. So this is the first thing that I wanted to say. As an operator, also it is important for us to be part, in a way, of the governance regarding space activities and the legal framework for space activities. To be part of the governance, well, there are different ways to collaborate with the institution, for instance. That's what we did as a French company. We collaborated with our French agency in the drafting of the amendments to the French national legislation. So this is a way for us to have our voice heard with our national entities. A second way is, of course, that today the operators in space, we are having activities, and we developing innovative activities. I know it very well because ExoTrail is an in-orbit servicing company, meaning that we are developing an OTV, an orbit transfer vehicle, with several objectives, being to grab, for instance, another satellite, to deorbit it, or to do the last mile delivery for customer satellites integrated on board. And as such, as we have new activities, then we develop the technical requirements to perform our activities. So in this way, we are not developing standards, of course, but we are developing techniques that can be discussed with national or international institution to set up standards. So these are the first words I wanted to give.
So I beg to disagree on the point that it's the companies that make up new rules and laws, because even if it might be perceived that way when companies, especially big companies with a lot of satellites, start acting in a certain way, that it is said that also shapes regulation. But it is a state in the first place who lets that company act that way. So it is still it's a decision by the states how should that be done, and it's a state letting that actor do that. And especially if you look at the big companies today who are in a position to maybe shape regulation, they are coming from a country that has space legislation. They are operating under a national license, and they are not operating outside of any law. They might not be operating that much in what we have discussed in the case over the last 2 days, but they are acting under a national law. They have a national license that allows them to act that way. Thank you.
If I may, but this involvement of private entities and private actors is also visible in the emerging of national space legislations, because they are reflecting the needs of the non-governmental entities, actually. So we can see it, as Professor Malinowska mentioned, about the Polish space law, which enter into force next week, probably. And the private actors, they are shaping also the environmental of space activities, the growing number of space debris. There are hundreds of launches per year, the thousands of space objects which are launched and deployed in the orbit. And example of Polish space law again, the situation when the space debris fall into the territory of Poland on February 2025. And actually it has some reflection in our national space legislation, where the chapter about what to do when you will find a space debris, or you will assume that it can be a space debris, what you can do with these things. So I think that this growing activity of space actors is visible in the emerging of national space legislations, which starts to follow the activities and the development of private entities and their activities. So they are somehow reflecting these issues.
Yes, and if I may react directly, please. I'm not saying that it does not have an influence, and I'm not saying that states should just regulate without talking to the people who that law will be applied to. But I understood the introduction that we are at a point where private actors are creating regulation and are shaping regimes without the states playing a part in it, and that's what I contradicted to. But of course you're right, and I'm convinced it's the right way. If you want to draft a law, like with a lot of public decisions, when the government acts, those who are affected by that should have a say, and there should be hearings or ways to get their input. They should not make the decisions and not write the law, but when writing the law, their interests should be taken into account. Thank you.
If I may bridge both of your points, I feel like what you're saying is correct. I don't think that private actors are able to determine law if the state is not there. But for instance, like in Portugal, we had the public consultation process when drafting our first Space Act. And this is the way that, so private actors are providing input, especially because space law really needs to hear regarding engineering, technical standards to adapt properly to provide the correct regulation. But at the same time, I'm not so sure we are in, especially coming from, I'm the odd one out. I'm the public international law guy in this panel, and I think that private actors have always been there precisely because states listen to them. If they're listening more now than before because of this new space economy vibe, maybe. But I also wonder if we are opening a new path in international law, that if it's just private operators that we want to hear, if we're departing from a state-centered international law, if it's private operators alone that we want to hear, or do we want to expand more to have other groups, different perspectives? And we heard Roda in the last panel speaking about indigenous perspectives as well. So.
From the industry perspective, I think it's a close collaboration between the governments and the practical realities of what we're facing. If you have a law that has too many regulations or too many requirements, or those who are not necessarily well defined in terms of scope, impact, or anything, that to us can have a severe financial impact on our activities. And when we speak about, private companies, usually we speak about, or we think about the big actors, the ones that have millions and millions of euros or dollars or whatever. But coming from a smaller company, so iSpace in Europe is 50 employees, globally we're 350. We do have to be taken into account also on this front, because the financial impacts of just having a mission authorization to operate in space is something we have to take into account in our budgets. So if you introduce, requirements without consulting the private sector, you take the risk to, completely suffocate your innovation. And, we bring flexibility, we bring, innovation and quickness in terms of the missions compared to the national space agencies, for instance. So it is very much an interdependence kind of situation, therefore the collaboration between the two.
And, I fully agree with you, and also what you said about the other perspectives, and that's what is my main point there when talking about the public consultation or hearing interested parties or hearing stakeholders out. You have to make sure that it is not just the industry, and that is you can get the impression sometimes that nowadays people listen to industry, or governments often listen to industry and want to write regulation that is good for industry, but you also have to take other interested parties into account. especially with satellites, especially astronomy, for example, where we have a big discussion also in Corpus about the topic of dark and quiet skies, where you have impairment of astronomy in the visible spectrum and the radio spectrum through the numerous satellites that are now in low Earth orbit. And that's why you have to hear all those stakeholders out, but in the end, the decision has to be made by the state. And you invite the people, you hear them out, and then, just like we did today, we heard both parties, then we sent the students out and made a decision. And I think it's similar how the state should do it with the regulations, also on the international level then. Thank you.
Just quickly, if I may, it's just about the balance, because you have a different interest when it comes to, and that's the challenge, for example, for drafters of the national space law, by the way, and that's the balance between the different interests and how to regulate it in the proper way. So that's what we, for example, were witnesses.
Just to concur with what you said, the industry, we are not expert in drafting laws. This is not our job. No, definitely not. So this is your job. You're very good at it, but it's not ours. What we want to have is the opportunity to explain our situation. And even within what we call the industry, as a generic term, we have different interests. So the balance you were talking about is very important, even when dealing with industry request or a situation. So.
Just a quick follow-up, really quickly. So, when discussing this topic, do you think that regulators are leading, or are they reacting to the new situation, or are they leading the new situation?
Well, in my opinion, they should be leading and not just reacting.
And now, how they are acting?
Yes, that's. I mean, it depends whether you're talking about the national level or the international level. On the national level, it's easier because a government can make a decision and bring a law through parliament, or the legislator can come up with a proposal. On the international level, we have to reach consensus. We have to find states that are willing to sign an international treaty, and that goes a bit back to what I said in the beginning. So those industry actors who now have a big influence and just act the way they think it's right, and then try to push that through as a rule, they have a state behind them who says you can do it that way, and a state that is maybe not so interested in strict regulation on the international level. There are other states, especially those that do not have that many space activities yet, who are very cautious about that and who would like to see more rules and even more restrictive rules to make sure, and that was touched upon in the earlier with the questions of sustainability. You have to make sure that also future generations have access, and there are quite some countries who have to wait for the future generations to get access for their countries, and yeah, it's a neat balance. Or it's difficult to find the balance there, and it's easy to obstruct consensus building, because you need just one party who says no, and then it's all gone. Yeah, but so it's. I would say it's different. On the national level, regulators can lead if they want to, and if industry leads on a national level, that's a decision by the national regulator. On the international level, it's difficult because of this consensus situation. Thank you.
I want to react on the national part of the leading of the regulators. So if I take the example of Luxembourg, Luxembourg published the Space Resources Law in 2017, and that came from the Space.lu initiative that was launched in 2016. Back in those days, so 10 years ago, talking about utilization of space resources was, completely abstract, very futuristic, and there was no missions really dedicated in Luxembourg that were going to launch anytime soon. And actually, the first time that law was used was in 2024 when we received the first authorization provided under that law for a launch that happened in 2025, and attempting landing in June 2025. So 9 years after the space.lu initiative. In that case, that's a clear example of leading, the regulator leading and betting on the future of the space resources activities. But I agree that on international level, it's another completely other ballgame.
Yeah, actually, I wanted to refer to the same in the sense that it's a question about the following the technology and if the law is following the technology. So, for example, you said about the space resources. We were thinking about what to regulate. Should we regulate the space mining? Should we regulate the in-orbit servicing? So that's the question of the update and following the activities and the development of space activities from the private sector too.
I'm going to also add points on the international level because, especially in your mentioning space resources, I feel that not only, we are not able to reach consensus in many aspects, but there's a certain fear of anticipation, of jumping the gun too fast and then you just hinder innovation. But I don't think that's an excuse. I also think that at the international level, it is necessary for states to lead and anticipate. You don't have to regulate everything to the detail and then curtail innovation and the private sector. But at the same time, you need to anticipate some basic issues. Because then, at some point, of course, operators want sustainability, but they can also want a race to the bottom in many aspects, favorable regulation, precisely like weak regulation in some situations. So I think at the international level especially, we need to find a way of building consensus to anticipate on basic issues so we can avoid races to the bottom, or at least a laissez-faire approach.
And if I may just add one sentence, especially in the space sector, the states proved with the Outer Space Treaty and the following treaties that it is possible to find regulations in principle with the Outer Space Treaty and then more concrete with the following treaties that did not hinder innovation. Otherwise, we would not be talking about resources extraction, on-orbit transfer vehicles, active debris removal, and so on. That all happened, if you're following this regulation hinders things, despite regulation being there. So I don't get why so many people are so afraid of regulation and only see the bad in it. Thank you.
Okay, if I may react. Well, as an operator, I see the regulation as a framework for our activities, and I am not afraid of having a regulation. I am from a French company, so I am ruled by the French space law, which is known as one of the most constrained in the world. I'm used to it, and we are quite happy to have regulations. A regulation that gives us confidence on the activities we are performing. The issue, on the other hand, is not the regulation itself, but the difference between different regulations, which means that the operators will not be in the same situation or in the same position, depending on its applicable regulation. So we are not in a view to have a weak regulation. We want to have a regulation that is homogeneous for all operators.
I echo that, and if I may add as well, we want a regulation that is practical and reasonable for space actors as well. So, when you say, I don't understand why actors are afraid of regulations, the reality of the practice is that we depend on budgets that are usually very tight, especially for mid-sized to smaller companies. So if you have, again, going back to my previous point, your regulations that impose requirements that create a financial burden on the actor, that are not all the actors are able to bear that financial burden. An example of iSpace, for instance, is that in the mission authorization we received for M2, so the one I just mentioned about the 2017 resources law, there is an obligation in this law that we need to provide audited reports for our last 3 financial years. According to the actual law about audits in Luxembourg, we're too small to be audited or to have a legal requirement to be audited. So we were in that middle ground of what should we do? And after discussing with the Luxembourg government and explaining our situation, we decided to have our financial years audited for 3 years. That is a huge amount of money for our company that we didn't necessarily plan, because we were not necessarily taking that into account when we planned a mission 5 years before. So that's a very practical example of why if the regulation is drafted in a restrictive way, it can be scary for the industry.
Okay, moving towards sustainability a little bit. The rapid rise of mega constellations and the rise of, expanding the connectivity and services on a global scale can create some problems on Earth's orbit. So can this level of expansion remain compatible with the long-term sustainability in outer space? And at the same time, who should bear the primary responsibility for ensuring sustainability, the private sector or the public institutions?
May I start? Okay, so first of all, I think that question is really complex, and I think that it's what was mentioned already in the previous panel is the universalization of standards. So the question appears here for the best practices and the exchange of the best practices and standardization at the level of maintaining the sustainability between the space stakeholders. So that's the first thing when it comes to the question. And the second, who should bear this responsibility? I think it should be a shared one, because all of the actors from the public perspective and the private perspective are involved in the space activities. So their interest is to maintain the and mitigate the risk of collisions of space debris, of creating a lot of risk to all of the activities from the public and private perspective. So first of all, this best practices, the sharing of the best practices, the standardization, because a lot of national space legislations refer to internationally recognized standards, which are then somehow indicated in a detailed document, so they are not universal at all. So maybe the European Union Space Law, the proposal, will be some kind of a solution for this universalization. And the second one, the responsibility should be shared in this level, because all of the actors are involved in it. So that's the point.
Okay. So, okay. One word on the mega constellation or constellation, whether they're mega or not. My company is in orbit servicing company, so we don't have multiple satellites in orbit. We have launched one 2 years ago and a second one 1 week ago, so we have only 2 satellites in orbit. So we're not concerned by constellation, except when we're talking about mobility in space, because our satellites are equipped with engines on board. They are OTV, so they are moving in space, and we need sometimes to have shared information with some operators with regard to our trajectory. So, and this is something that today, this is a subject that could be discussed at national and international level, which is the sharing of information regarding the in-orbit positioning or the in-orbit mobility of some satellites. And so what we are pleading for is a cooperation at the private level, private company level, but also at national and international level in the sharing of trajectory plans.
If I just want to pick up on actually something that Martin said previously, because, okay, so we're addressing the issue of the orbits and long-term use and sustainability. The point is that I think about not only of in space, so mobility in space, I also think about the issue that you mentioned, astronomy, for instance, so crowding of orbits. And will it become sustainable in the long run? I feel we have, it depends on how we address also escalation of risks. But if we consider these perspectives, like, is it going to be sustainable in the long term of doing Earth to space astronomy, looking at it? This is a perspective that we have to consider in the sustainability, and obviously 2 satellites is not is not problematic. But if we're thinking, could be the beginning of the problem. Depends on how you do it. But if we're looking at mega constellations in the thousands, we already have problems. And as you precisely mentioned, they're already affecting astronomy to some point. And this plays into sustainability and long-term use, because outer space is not just being in outer space, it's also looking at outer space.
To answer your question about whether it's sustainable, in my opinion, it's not. And it's very clear that it's not. Starlink, if I recall correctly, went over the 10,000 satellite threshold lately. And I mean, ITU filings are not proof that there will be so many satellites. But if you look at ITU filings, how many satellites belonging to constellations could be there, even if it's just a fraction of that, that's way too much. So we will have a problem there. And in the end, I don't know how it will work without strict regulation. And I'm not talking about, overburdening regulation, but just some rules that are applicable to all internationally and that have to be strict to ensure that it's not just our generation or nowadays companies or just the companies that already are in space, but that also in the future others can still look at it. And if we look back in history, that's a very typical problem that we have with industrial development. You have an externalization of costs. A lot of developments focus rather on short to mid-term profit instead of looking at the long run and how to make sure that you can still profit from something in 50 or 100 years. And in the end, it all goes back to the tragedy of the commons.
Okay, moving on to the one of the most debated issues today is how to interpret Article 2 of Outer Space Treaty, which prohibits national appropriation. We are now entering a phase where commercial ambitions extend beyond Earth orbit, particularly in relation to lunar exploitation and the potential use of space resources. These developments are often framed in terms of opportunity and technological progress, but they also reopen long-standing questions about governance, equity, and environmental limits, this time on a much broader scale. So, do these developments require a new balance between innovation and restraint?
I think I can answer that one. So just a bit of context in terms of resources. So the reason why we had the authorization under the 2017 law is because back in 2020, iSpace signed a contract with NASA for the purchase of a little bit of regolith. And I want to put everyone at ease, we're talking about a few grams before we're talking about mining. So it was very small. So it was a small scoop. The rover was 5 kilos, so probably this height. And the scoop was scooping a bit of regolith and keeping it inside of the rover, and without the ambition to bring it back to Earth. It was just a legal transfer of ownership, and it was framed as more of a legal test, if you want, to see how the legal frameworks would withhold that kind of transactions. So, NASA being in the US, of course, they were allowed with the 2015 law in the US allowing for the commercialization of space resources, and we were allowed in Luxembourg with the 2017 law. We also had a second contract with iSpace Inc., which is based in Japan, and Japan also has that kind of law. So, we were doing that kind of legal test, if you'd like, from various jurisdictions. I think, going back to your point, the main question is not necessarily about, the whole mining aspect of things, because the technology is not there yet. So we do still have some time to, see how those legal frameworks withhold international scrutiny, even panel discussions to an extent, and to adapt as well. What I can say though is, from our operator perspective, we want to be a good actor, we want to do the right thing, and we want to work sustainably, we want to work with the Luxembourg government. Our goal is not, to go and exploit the moon. We actually don't use the word exploitation, we use the word using those resources, and we don't want to go there and mine everything and bring it back on Earth. What I find really interesting with the 2017 law is that the level of rigor that went into the whole process for us to get the authorization was quite extensive. Just to give you an idea, it took us roughly 9 months to have from the very beginning of submitting the documents to having the mission authorization. And that was because we had to prove, the technological readiness, what we were going to do with the rover once it died because it couldn't survive the lunar night, whether or not we, were going to be respectful of the environment, how the extraction was going to be made, where exactly, in what range of the lander, whether or not we were going to survive if we crashed, financially speaking, because Luxembourg did not want to authorize a one-off mission. And there was a lot of, scrutiny and rigor and methodology in that, whole process, because we were very conscious, both the Luxembourg government and ourselves, that we were creating a precedent with that authorization in Europe. So to go back to your point, I think, again, the collaboration between the private sector and the government is absolutely paramount in those situations, and at least I can speak on iSpace's behalf, but we want to be able to do the right thing, and therefore we need the guidance from the government as well.
I'm going to step on this as well, because this is my main topic of research to some extent. I'm going to skip a few steps ahead, because honestly, the vision of iSpace, it's in that sense, it's okay. But my concern is not iSpace, is is the rest of the landscape that is too often too worried of looking into outer space as opportunity for profit, and completely forgetting that outer space is also nature. So that's all good. So, but I think in the long run, we need to start thinking of some checks and balances. And we need to start thinking about the economy that we're going to build around space resources. I'm a very pessimistic person when it comes to this type of developments. In the sense that if we look into the way global economy usually works, I don't think that we should reproduce this in a space resources economy. If we're going to do the traditional thing of first, in building this new sector, we first stabilize, then we grow, then we distribute, we are going to fall into the same old fallacy. And so I think we need to start thinking of it towards this. towards, we are talking about shared domain and notwithstanding some US executive orders, a global commons. So we need to start thinking about this, like distribution as well, not just concentration, but distribution at the same time as we do stabilization and growth. Because if we're going to do first stabilize, then grow, then maybe distribute, we know what's going to happen, no distribution. But honestly, this is not against iSpace. You all know what kind of companies I'm thinking about.
Okay, thank you very much to our distinguished panelists. Thank you very much for coming. I think I can tell that it's the end of this conference, and I'm really glad that everybody came. Thank you very much again.